Hi there, thanks for joining. My name is Emily Newman. I'm an attorney and partner with Reddy & Newman PC and also the writer behind ImmigrationGirl.com. I'm here today with one of the attorneys from our office, Stephen Brown. Thanks for joining. And so we are here to answer your questions on all the latest that's going on with employment-based immigration. So we have a couple questions that we didn't get to last time, so we'll try to start with those. While new questions come in, feel free to ask your questions in the comments, and we'll see how many we can get to today. So one question someone had from last time was regarding, they've got an I-140 approval, it's been approved for more than 180 days. If I transfer to my new employer, can I keep getting extensions based on the approved I-140 from the old employer? And the answer to that is definitely yes. Under the memo or the regulation that came out in January of 2017, it's been on the books for over a year now, they said that if the I-140 has been approved for at least 180 days after the January 17th memo and has not been withdrawn, you can use that with the new employer. And even if it has been withdrawn after the 180 days, you can still use that I-140 to get H-1B renewals beyond the 6-year limit, H-4 EADs for spouse, as well as keep that priority date. Let's see, we had a question about, it comes up quite a bit about the H-4 EAD. You know, if you are, say, filing a transfer and you want to file your H-1 transfer plus an H-4 extension and an H-4 EAD, but you already have an H-4 EAD that's valid for, say, another 6 months, can you still file the H-4 EAD?
Yes, Emily, you can. In fact, I just did it this afternoon. You can file the H-4 EAD early, more than the 90 days or the 120 days. It can be filed with the H-1 whenever you're doing that transfer.
All right, one other question that comes up quite a bit is, can someone who's on the H-4 EAD be sponsored for the green card? And the answer is yes. You don't have to be in H-1B status only to have your employer sponsor you for the green card. I don't see any reason not to do that. If you have an H-4 EAD, you can be sponsored anytime for the green card process on your own as well.
One of the questions we received is if you have an H-1B that is valid until June of 2018, you filed an extension, that extension was denied on April 28th, 2018. Can the individual H-1B holder continue working on the previous H-1B until June 2018? And the answer to that is yes. Because you have the approval that is going until June 2018, you can continue working on that. Obviously, you can't keep working beyond that because you don't have the extension, but you can keep working on what's currently approved by USCIS.
All right, so one of the big questions that I'm getting over the last 2 days is what's the latest on the H-4 EAD? And the reason that it's coming up all of a sudden, where it was not so much of a hot topic before, is based on a letter from the USCIS director to Congress, basically letting them know where they stand on their immigration reform and their actions for regulations. So in that letter, the director of USCIS informed Senator Grassley pretty clearly that USCIS, Department of Homeland Security, is in the process of issuing a proposal to eliminate the H-4 EAD. So now everyone's talking about the H-4 EADs no more. We already knew that was coming. Every single item in that letter is based on the regulatory agenda that came out in December. So there's really nothing new there. So I'm not sure why it's a big topic all of a sudden. It's nothing different than what was published in December. We know USCIS was planning on issuing a new regulation on employer-employee relationship for H-1Bs. We know they wanted to modify the definition of specialty occupation to make sure the visas go to the best and brightest. And we know that they wanted to get rid of the H-4 EAD. We got even further confirmation of that as part of the litigation where the Trump administration had to give their update to the court and let them know that although we expected a proposal in February, it's going to be delayed until June. So pretty much in June, we should expect at least a proposed regulation. Now remember, it's got to go through the whole regulatory process. So Stephen, can you give us a idea of what that entails?
For the regulatory process, a regulation is going to be proposed, and from there's going to be a notice and comment period, and during that time, interested parties can make their comments about the proposed regulation before it's voted on by the regulatory agency to adapt.
So remember, the director of USCIS cannot single-handedly revoke the H-4 EAD. The H-4 EAD is still valid. You can still file it. You can still get approvals of it. That will continue until a final action is finally taken on a regulation. That is a several month long process. We may be looking at a year before we finally get to a final rule. There may be litigation anyways to stop the final rule from taking effect. So continue filing your H-4 EADs. No issues there at all.
Rajesh had asked, what happens to H-4 EAD application and the fee paid towards it when an H-1 extension gets denied? And that's a question I do a lot with H-1s and H-4 EADs, and it's a question I get asked a lot. Unfortunately, if USCIS receipts the case in, the H-4 and the H-4 EAD, that fee is gone. Because the extension is being, the H-4 and the H-4 EAD are being applied with the H-1B extension, the H-4 EAD are likely to get denied as well. In fact, they will get denied as well because they are dependent on the H-1B holder.
So another question that's been coming up quite a bit is related to the STEM OPT and whether you can work at a third-party location while you're on the STEM OPT. Now, this is based on an update to the USCIS website, no other official announcement, but the USCIS website was updated apparently in January with some additional guidance about what kind of employment qualifies for the STEM OPT extension. And they're pretty specific about indicating that students who are not working in-house at the employer's location, the employer that's signing the 983 training plan, will not be able to be approved for the STEM OPT extension. So we have not seen any implementation of this or enforcement of this. I would expect for those that are getting ready to apply for their STEM OPT extension, it may be possible that you won't be able to get the I-20 from your school if the I-983 form indicates you're working at a client site or you're working remotely from home or remotely from anywhere. You can only work in-house. The purpose of STEM OPT is for training. You can only be trained if you're there in the office being closely supervised. That's kind of where this is coming from. In addition, the thought process behind it is that ICE, which is the agency responsible for enforcing the student visa requirements, is not able to walk into this third-party location to find out what's going on during a site visit. So these, in order for ICE to do a site visit, they can only do it at the employer's location that signed the 983, because by signing the 983, the employer is giving ICE permission to do that. And so that is also one of the reasons why it looks like going forward, third-party placement or remote assignments will not be an option for STEM OPT students. We don't know what's going to happen for those that have already done it or are already there, already have their STEM OPT approved. It's very possible the issue may come up in a change of status application. For example, if you filed your H-1B this year and get selected in the lottery, you may see a request for evidence on that issue. Srinivasan asks how long an MTR will take. And there's really no answer to that question because there's no required timeline.
They can take a long time. I filed a couple last spring, a appeal, which is a similar form to the MTR, and we finally got responses almost a year later. I usually tell people it can take around 8 months and sometimes longer to get a response on those MTRs as well as appeals.
All right, Sumant has a question related to the H-1B lottery. So first, let me say that we are still getting receipts in. So far, the only receipts we've gotten are still only for advanced degree master's cap filings. We've received receipts in about 20% of the cases that we filed in California and maybe 19% at Vermont. I might have that backwards. No bachelor's cap receipts have come into our office yet. And so Sumon's question is for F1 students. A lot of rumors going around that you can use the new SEVP portal in order to find out if you've been selected, even if you haven't gotten a receipt yet. And my understanding is that that only works if you are going to be in the cap gap to where your OPT is expiring sometime between April 1st and October 1st. The employment end date in your history tab gets changed to September 30th to show that you've been approved for the cap gap extension of your OPT. So yes, that is possible. I don't believe it's possible for other students who are currently studying or who have the OPT valid beyond October 1st. Any issues with SOC code computer programmer, and what if it's wage level 3? What are your thoughts on that?
I think computer programmer, after the guidelines put out by USCIS last year, is likely to be an uphill battle, even if it's level 3, level 4. They came out pretty strong last year saying it's most likely not a specialty occupation. That's not to say you can't prove that it is a specialty occupation. I wouldn't recommend trying to go that path. I'd work with your employer and seeing the SOC codes are a broad range, and your employer can. There are other options out there that you might be able to find as a better fit to your job description.
What do you think would happen, going back to the H-4 EAD, when we get a proposed regulation, the public comments on it, and after all of the public comment, they basically ignore all the public comments and still go ahead and revoke the H-4 EAD? What options do you think are there?
I think you can see plenty of immigration advocacy groups going ahead and litigating it, and they'll probably go to courts that are friendly to immigration and try to delay it further, try to get what's called an injunction, which would prevent them from enforcing those new regulations. And then from there, they're going to hopefully get an injunction that lasts throughout the length of the entire case, possibly a nationwide injunction depending on where it is and who the judge is. And from there, it's going to go through the whole litigation process, the appellate process, and it's going to be a long process. I mean, when you're talking litigation, you're talking at least probably a year to get anything done.
All right. Jagadish has a question about the situation where a perm labor certification has been denied and an appeal has been filed or a request for review has been filed for that denial. Kind of what are the chances of getting approved? I have no way of answering that because I have no idea what the reason for the denial was. I mean, if the case was filed completely wrong, obviously you're not going to get it approved. But if there are grounds for approval, then it might be overturned. Now, if you want to file a new labor certification, do you have to go with a new employer? Can you file it with the same employer? When you file it with the same employer, it may require you to withdraw your pending appeal. On top of that, when you've had a denial with the same employer that you're filing a new labor certification with, it is pretty much guaranteed that your new case is going to get audited. Now, that doesn't mean it's automatically going to be denied, but you just need to keep that into consideration because the processing time is going to be longer. Now, if this appeal has gone all the way to BALCA, just be aware it's probably a 4 to 5 year wait to get a result from BALCA. So it may be a faster option to file a new labor certification, probably with a new employer if you switch employers, and then you won't have to worry about the potential for the audit due to refiling with the same employer. Okay, Benet has a question about whether the perm labor certification has to be filed again if the I-140 has been approved for more than 2 years, if this is with a new employer. And the answer is yes. So the only time you don't have to file a new labor and new I-140 when you change jobs is when you've already filed your 485 and it's been pending for 180 days. Under AC-21, you can take that approved I-140 with you to the new employer and start working for them immediately based on an I-485 that's been pending for 180 days. Those that are stuck in the green card backlog that have not been able to file the 485, you've got to file a new labor, new I-140 in order to keep your green card case going. All right. Yeah, Shaker has a question about the H-1B petition that was filed in the lottery way back then was filed in the master's cap, even though it was a for-profit university, which technically does not qualify for the master's cap. He's hearing about notice of intent to revoke NOIRs being issued for that. Have you seen any of those before?
Yes, I've dealt with 2 of those over last summer of 2017. Unfortunately, both were unsuccessful. What USCIS is saying is that the case was improperly filed to begin with, that those for-profit universities don't even qualify as institutions of higher education under the Department of Education definitions, and therefore shouldn't have been filed in master's cap, should have been filed in bachelor's cap. That's not to say it's a guaranteed notice of intent to revoke. It's not to say it's, you're going to have your case revoked. I would consider at this point possibly refiling in the next year's lottery to try to cure that deficiency in your petition. And that should, and file in bachelor's cap at that time using the undergraduate degree from either U.S. or from overseas. And that's the best way to cure that, and keep hoping that they overlook it for now.
All right. Seetha Rodman has a very common question. Given the current situation, would you advise to file the H-4 EAD? Based on where things are now, the H-4 EAD is 100% valid. You can get the approval. You can keep working on it as long as the H-4 EAD is valid. There's no reason to not get an H-4 EAD right now. Now, for those of you that maybe are on H-1B right now, and then looking to switch to H-4 EAD, I also don't see any problem doing that, because later on, if things start to go south with the H-4 EAD regulation, you can always switch back to H-1B, file a change of status, premium processing. You don't have to go through the cap again. So if you've been counted in the H-1B cap before, you don't have to worry about being counted again when you're switching back from H-4 to H-1B. So I see no reason not to file an H-4 EAD. The regulation is 100% valid. It's not going anywhere tomorrow, not going anywhere anytime soon. Even when they propose the new regulation in June, you still can get the H-4 EAD. Nothing happens to the H-4 EAD until a final rule is actually published in the Federal Register and you cross the effective start date of that final rule. That could be at least 6 months from now, probably longer, and litigation probably going to make it even longer than that. All right, Nirmal has a question about travel. I'm assuming this is someone who's filed in the cap this year. Assuming that you get the H-1B approved before October 1st, can you travel? And if you do, can you get the visa stamp and come back into the country? Oh, but here's the thing, before October 1st. So the visa only takes effect from October 1st when you're getting the stamp for the new cap petitions. Now, there is a provision that technically allows you to come in up to 10 days early. However, I'm not a fan of taking advantage of that, because that doesn't mean the particular officer at the port of entry is aware of that provision. So because you just don't want to get into a situation where you're coming in, you get all the way here, and then you get turned back for some random reason, I generally would not recommend coming back until October 1st for an H-1B visa that's starting on October 1st. Lots of questions about, shall I file for the H-4 EAD? Ooh, any denials for computer systems analysts?
Yes, unfortunately we have seen a lot of computer systems analyst denials. That's coming from 2 reasons. The USCIS is using a lot of the government documents from the Department of Labor. They're using the ONET, which is showing only about around 45% degree rate, which means that between the between bachelor's degrees and master's degrees, their analysis has concluded only 45% of systems analysts have a degree. They're taking that and also applying the Occupational Outlook Handbook, which is another DOL tool that says includes a wide range of degrees, including liberal arts, business, and any other fields for computer systems analysts. And what they're concluding is that there's a low degree rate, and on top of that, the degrees can be in any field, and therefore it's not a specialty occupation because the position does not require a degree in a specific field, which is what is required for specialty occupation.
Let's see. We had a question about someone who filed an MTR last year. So I assume you filed in the CAP last year, got selected, great, and ultimately, unfortunately, ended up with a denial. Filed an MTR or appeal, not sure which, and then filed again this year, probably with the same company, I'm guessing. Is that going to be considered a duplicate filing? No. Those are 2 separate years, and there's no problem with that at all. If the MTR is still pending or the appeal is still pending at the time the new petition is selected and they're getting ready to adjudicate it, there may be a request for evidence asking you which case you want to proceed with, and then you can decide at that time and withdraw the other one. But I see no problems, and I've not had any problems with having an appeal pending from last year and a new petition filed and selected this year. So Chowdhury again asks about the STEM OPT and what is the update with the new rule. Now let me make it clear, there is no new rule. No change in law, no change in regulation, no guidance memo, nothing. The only thing that happened is USCIS updated their website. Maybe that's something that could be litigated, I don't know, because that's not really a way to give the public notice of changes in interpretation. But there is no new rule. It is just that USCIS added some extra guidance on their website suggesting that, or saying that, they will not allow third-party placement for STEM OPT students. All right, when do we expect to find out the lottery results? So in previous years, we usually receive all the receipts by May 15th at the latest. We got another big packet in the mail today. I expect that to continue through the first week of May. Usually between May 10th and May 13th, somewhere in that range, USCIS will make an announcement that data entry is complete. From that point, it usually means there won't be many more receipts coming. The last of them will trickle in, and then shortly thereafter, we'll start getting the not selected petitions back in the mail. So by May 15th, if you don't have your receipt number or your receipt notice in the mail, chances are not looking good. Yes, going back to the H-4 EAD, Neha asks, once the proposal comes out in June, will USCIS stop approving the H-4 EAD renewals? No. The H-4 EAD rule remains valid until an actual final rule is announced and takes effect and there's no litigation. So just because they propose something does not mean it's a final rule. There is a chance that maybe public comment will sway them one way or another. That remains to be seen. But the H-4 EAD will still be issued even after June when a proposal comes out, if it comes out. Now, another question on that, Murali asks if I'm assuming if all things end up happening and the H-4 EAD rule is no longer in existence, will people that already have one be able to continue working on it until it expires? We don't know because we don't have a proposal yet. I would expect that the proposal will tell us how they plan on dealing with that transition period. I would expect, based on how they treated DACA recipients, that yes, you should be able to continue your EAD until it expires, but we'll have to wait for official word from USCIS on that.
And I think that the DACA analogy there is a pretty good one. Look how long that's taking to go through the whole process and the litigation, and that's a good analogy to use, I think. Yeah.
Abhishek has a question about filing the H1, H4, and H4 EAD renewals in premium. H1 got approved. H4 EAD are showing still pending. Are you seeing that happen very often?
It doesn't happen a lot, but it can happen. The service centers are not obligated to process the H4 and H4 EAD in premium processing. They typically do it as a courtesy, but it's not required. It's possible that they separated the H4, H4 EAD for some reason, and that those will be adjudicated in regular processing. Unfortunately, there's not a way to expedite those. You can't turn around and say, well, I filed these in premium, because they'll turn around and just say, that was a courtesy.
All right, Nirmal asks if you should stay with the old employer for 180 days after the I-140 is approved before you move to a new employer. Yes, that is a good idea if you have that option, because that's the only way to ensure that even if that I-140 gets withdrawn, you can still use the I-140 for continued H-1B extensions beyond to the 6th year, even with different employers. You can still use it to get the H-4 EAD, as long as that's still a rule, and you can still use it to keep your old priority date. So yes, it is a good idea to wait 180 days after your I-140 is approved before trying to change employers. Let's see, already answered that. Okay, Sarvesh has a question about the interplay between H-1B getting selected in the lottery and filing the STEM OPT extension. Can you do both? And the answer is yes. So even if your H-1B is selected in the lottery, if you're eligible for the STEM extension, you may want to consider applying for it anyways, even if you may not eventually need it. If your H-1B gets approved, you don't need it. But it's a good idea to have it in your back pocket, because these days the H-1B adjudications are a little tougher than they've been before, so there's no guarantee that you'll be approved just because it was selected. If your H-1B is denied, you have the STEM OPT in your back pocket to use to keep working. Another benefit of applying for the STEM OPT is that if you only rely on the cap gap to keep working, if your H-1B takes longer than October 1st to be approved, once you hit October 1st, if you don't have the STEM extension, you have to stop working until your H-1B is approved. So it's a way to ensure that you can keep working regardless of what happens to your H-1B. So it may be overkill, you may end up not needing it, it may end up being a waste of money, but I think it's a good waste of money just to have that peace of mind and a backup plan in case you need it. Do you see any reason why an H-4 EAD filed a week ago would run into problems?
No, I don't see any reason. It should just be adjudicated, normal processing, premium processing, whichever it is. But I've been filing H-4 EADs and haven't had any issues with them yet.
All right. Radhakrishna asks about wage level 1. Can you still get an H-1B? Is that still considered a specialty occupation if you're under wage level 1?
It's been hit or miss. USCIS has been trending towards that level 1 is not a specialty occupation. I also see that you asked about the factors for a level 1 wage. There is a long Department of Labor guidelines, I think 30-something pages, on choosing the right wage level. And what USCIS is relying on is that a level 1 employee is an entry-level employee that is supervised, they're told what to do, and they are told how to do it. And what USCIS is saying is that there kind of seems to be a rub on someone who is so specialized that they're doing so complex duties, and someone who's entry level that has to be told what to do and how to do it. And that is how USCIS is handling that level 1. It's not necessarily an automatic denial, but it is going to give you an uphill battle on getting it approved.
All right, Suresh has a question about stamping, and if you're eligible for the drop box, should you go for visa stamping? Is it easier? Should you expect problems? Right now, if you don't have to travel, don't travel. Don't go for stamping. Even if you can do the drop box, they're still calling people in for an interview, and then they're giving a 221G, and then it's delay, delay, delay until you lose your job, and then you're left with nothing. So if you have your H-1B approved, unless there's some life or death situation, I do not see any need to travel. Especially if you need to go for stamping, it is not the time to do it. It is tough right now. Neha asks about the chances of getting an H-1B for a position like an IT recruiter. You think that's going to run into trouble?
It a lot depends on the ONET and all. I would think that USCIS would likely say that it may or may not require a degree, especially in a specific field. And I'll give you the perfect example. Right out of undergrad, before I went to law school, I did IT recruiting. And I can tell you that my major and some of the other majors of the people that worked with me were not in a specific field. It was business, it was leadership studies, it was history majors. It's a wide range of fields. So I think you're going to run into a problem on specialty occupation, proving that IT recruiter requires a degree in a specific field.
All right, I'm going to sound like a broken record here, but again, with the letter that came out from USCIS recently, is there anything that's changed with the H-4 EAD?
Nothing. Nothing's changed. It's just pen to paper USCIS's stance that we knew back in December what their stance was given the executive order.
Yes, you can still apply for it. You can still get the approval. Absolutely nothing has changed on the current H-4 EAD regulation. We have a question about the 60-day grace period. Regarding, well, I'm not sure how it relates to the project ending, but once the job is no longer there, when do you count the 60 days?
So the 60-day grace period is to allow for if you've been terminated from company A before you're able to get to company B. It's not as much project-based as it is employer-based. So if you're with company A and they terminate you on May 1st, you'll have 60 days from your date of termination to find another position with company B, company C, whatever, and find a new job that you'll be considered maintaining your status during that time.
Manoj asks if you've been getting approvals for people with a computer science background.
That's what I would like to see. Yeah, we get plenty. Computer science is a standard if you're doing an IT position. To say that a lot of those positions require a computer science background. That's not to say it's a guaranteed, but at least you're not having to fight the beneficiary qualification side of things.
All right. Dinesh has a common question that came up especially a lot last year. Once your H-1B is filed and it's been picked in the lottery, can you update the wage on the LCA?
No. Unfortunately, the LCA has to be certified at the time of filing in order to be considered valid.
Question about when can we know if the H-1B is not picked? I would say from about mid-May to mid-June is when we get all of the returned petitions back in the mail. So you should know something by mid-June at the latest. All right. Amit asks if his spouse can apply for the H-4 visa stamp in India while he's got an H-1B amendment in progress in the U.S. Do you see any problems with that?
I don't think so. I think that you can because you've still got the duration of stay approved.
Oh, Verinder has a question. Can I continue working while the H-4 EAD extension is pending? If your current EAD has expired, no. There is no employment authorization based on a pending H-4 EAD. So if it expires while you're waiting for the new one to come in, you have to stop working. Now that's different for STEM OPT. If you apply for the STEM OPT and your old OPT expires, you can keep working for up to 180 days. And that is the same thing for adjustment of status based EADs. If you filed your 485, it's pending, you've got an EAD, you file for the renewal. Now, based on the latest regulation, you can keep working for up to 180 days while the renewal is pending, but that does not apply to H-4 EAD. All right, Karthi has an interesting situation. Previously had an I-140 approved, previously on H-1, maxed out the 6 years, and switched over to H-4 EAD, been on H-4 EAD for some time. I-140 approval was eventually withdrawn. Can you switch back to H-1B, or do you have to leave the country for a year and go through the lottery? I think it's going to depend on how long the I-140 was approved for before it was withdrawn. If it was withdrawn before January 17th, 2017, I don't think that's going to work. If it was approved for at least 180 days and then withdrawn after January 17th, 2017, then you can still use that I-140 to get H-1B extensions beyond the 6-year limit. So you should be able to file a change of status back to H-1B, not subject to the cap, and get a up to 3-year petition approval based on the approved I-140 that was later withdrawn. Yeah, I think Vijay had a very similar question, but for his situation, there is no I-140 approval. So you could do that if you eventually get your own labor and I-140 approved. Then you could go back to H-1B without having to go through the lottery again and without having to wait outside the U.S. for a year.
Prakash has a question that I get a lot. Is applying for premium processing, an H-1B extension in premium processing, getting more denials or not? And I think the answer is no. I think that if you're going to get an RFE or get a denial, it's going to come. I think that the perception is different because you just filed the premium processing upgrade 15 days ago and then all of a sudden you get a denial. It kind of seems, cause and effect there. But it's not the case. If it's going to be denied, it's going to be denied eventually.
All right. Arun asked for an update on removing the per country cap on green cards. This is related to HR 392, which is one of the most co-sponsored bills ever in the history of the U.S. Congress. And so that bill would seeks to remove the 7% cap so that all countries of birth are on an even playing field. As of right now, it has not been brought to the floor for a vote, not been referred to a committee for discussion or debate or markups or anything like that. It's just sitting there with 300 some co-sponsors and no action being taken on it. I would definitely suggest that you contact your congressman and ask them to bring that to the floor for a vote, get moving on it. There's no reason to wait. This is something that so many people agree on. There's no reason not to remove that cap. If you look at it this way, let's say, last weekend I was at Six Flags in Dallas. I'm getting ready to get on a roller coaster, standing in line. I came with my friends. I have a friend from Michigan, I'm from Texas, and I have a friend from, let's say, Rhode Island. And we get to the beginning of the line, we get into the amusement park, we all paid the same amount for our ticket, and then we get up to that roller coaster and I get in one line, my friend from Michigan gets in another line, and my friend from Rhode Island gets in another line. Well, guess what? I'm sitting around waiting because there's lots of people in Texas. My friend from Rhode Island, nobody comes from Rhode Island to Texas to go to Six Flags, so the line is super short. They get on the ride, they're done, they're moving on to the next ride, and then my friend from Michigan kind of gets there a little faster than me, and I'm still stuck waiting. I paid the same amount of money, we went to the same amusement park. There's absolutely no difference between us except for the state that we're from. Could you imagine that actually happening? Like, there would be lawsuits all over the place. But that's exactly what we're doing with these per country cap. And how is that relevant to employment-based immigration? I have no idea. So I really think that people need to reach out to their congressman, get this thing to the floor for a vote, have your employers reach out to their congressmen. They do have a lot of sway, so your employer should be supporting you in this as well. There are a lot of big companies that have thrown their weight behind this, written blog posts about it, supporting their employees. So if your employer has not done that yet, please request them to do so. They should reach out to their congressman and ask that HR 392 move forward so that we can remove that 7% cap.
Yeah, never underestimate the power of getting in contact with your congressman and asking them to move forward with something.
All right, we'll see if we got one or two more questions we can take here. I think it's a lot of repeats at this point. But where's that H-1B extension?
There you
Yeah. Yeah, a lot of people are just asking kind of general questions about what are the chances of approval for anything. And we just can't answer questions like that because it completely depends on what's filed, how it's filed, what the wage level is, what the SOC code is the LCA certified, was it signed right? I mean, there's a billion issues that go into the success rate of any kind of case. So it's just not possible to give you any information on that without knowing what was filed. All right, I think that's about it, unless you saw anything else that we can respond to. So again, H-4 EAD, completely valid. The letter changes nothing. Proposal is going to come out in June. That still changes nothing. Until a final rule is issued, the H-4 EAD is good to go. So thank you for joining us. We'll have our next Facebook Live next Tuesday at 5 o'clock Central Time. And feel free to subscribe to Reddy and Newman on Facebook so you'll get updates when we're doing our next live video, and also visit immigrationgirl.com for the latest updates where you can ask further questions there. Thanks, Stephen, for your help today.